All right, well, good morning, everybody. I'm George Moore, and this is my presentation of frequently asked questions of Ohio probate. Like last wills and testaments, we've heard of those things, and probate, I'm here to kind of answer some of the general questions that most people have. And I see, Randy, you're already prepared. You've got a pre-listed two-sided sheet there, which is great. If anybody has any questions, or if you have any, there's some notes, notepads and pens there if you want to write those down as we go through. Usually I answer a lot of the questions in my presentation here, but if there's something that you want to stop and ask about, I'm very happy to do that. Or if something comes to mind, please, this is a back and forth here. So what is probate? Off the bat, I want to kind of point out there's really two overall pots of money is how I'll phrase it when somebody passes away. The first pot is everything that's dispersed outside of the probate process. And then the other pot is everything else, whatever is left over, if you will. Now, in either of those pots, you can have real estate or any personal property. So there's ways that you can title certain assets that they should pass outside the probate process. But what we're discussing at this moment here is what is probate. That is a legal proceeding, and it determines, did the deceased person have a valid last will and testament? They determine what the assets of the deceased were, and they determine what the debts of the deceased were, and then they make a court order that determines the distribution of the assets. And again, that's only with regards to the leftover pot of money, if you will, things that are not passed outside of the probate process. And a little bit later in the presentation, I've got some tips and insights on how to get some things maybe out of the probate process. But I first want to talk about a last will and testament. What is that? Okay, to be a valid last will and testament, an Ohio resident has to be 18 years or older, and they have to be of sound mind, and they have to understand that in the document that they're signing, they are disposing of all of their earthly property that's subject to probate, and in there they can also have requests for designation for guardian of minor children, or custodians for funds for inheritances that may end up going to a minor, such as to a child or grandchild or somebody like that. But generally, it's to dispose of your earthly property at the time of your passing here. And so, to be valid, it has to be in writing, and it has to be signed by the person making it. Two independent witnesses who are not taking anything, have no benefit under the will, they have to independently witness that. Kind of an interesting side note, there is no notary requirement for a will. That's a common belief that many people have. Some states may require that, but Ohio does not. At any time, you can change your estate plan, even after you've signed a will. There's a way you can amend your will, that's called a codicil. And then my general recommendation would be probably just do an entirely new one. And the standard intro paragraph says, I hereby revoke any and all last will and testaments that I've ever done before this here, if any. So if it's your first one, that's still fine too. How long does it last? Until you revoke it. You sign one original will. And that's because if you ever want to revoke your will, it needs to be as simple as you destroy the will. You can do that by tearing it up or shredding it or Xing through it. I would recommend, if you do that you let the attorney that prepared your will, know that you have just revoked that. And I would probably recommend maybe calling them first and seeing maybe that is the right decision at that time for you, but I would also recommend getting something else in place so you don't pass away without a will. It's not the end of the world if you pass away without a will. The word is intestate. And what that means is that the Ohio legislature has come up with we'll call it a path through the woods, if you will. And there's many trails leading off of this thing here. And depending on where you are at in your life, that will determine how your probate assets are distributed. So without getting into all the little rabbit trails, the questions kind of go like this. Did you have a spouse that survived you? If not, did you have any children that survived you? And if you have a spouse and kids, are those kids minors? Are all those kids with that present spouse? Were some with a previous spouse? Are any of those kids minors? Etc. And so you can see there will be a distribution order at some point. It may not be what you want. It may be what you want. I mean, it may all go to your spouse. And if that's what you want, great. But again, it may not turn out that way. You have a lot more control over the situation with a last will and testament. And so that's why I do recommend that even the younger people, you can make one at age 18, and I see no reason why you shouldn't. There's really no minimum estate size, that I guess would recommend to not have one, because even if you have this plan to get everything outside of probate, in case you miss something or something's overlooked or it doesn't go the way you think that it should, then you've at least got this last will and testament as a safety net that gives kind of hopefully your wishes will be carried out according to that. And there is no restrictions at all once you sign a will with regards to distributing your own property, disposing of your property during your lifetime. You can say in your will, I'm going to will my 2008 police car to my son, at my passing here. Well, when I sign that, I'm still free to go and sell that car. The court would just say, well, if he didn't have it at the time that he passed away, it's simply not an estate asset. Does anybody, I forgot to talk about executors. In your last will and testament, you can make a designation for who will be your executor. They will essentially manage your estate. I like to use the analogy, the estate of Elvis Presley. That estate earns money because people are still, I was going to say buying the records, but they're downloading the songs and buying the merchandise and all that. So many estates don't have this ongoing income that come into them. But, that estate is seen as a person, if you will, but they need a living physical person to be able to sign the documents, to act on behalf of the estate, to sign the checks, to make the ongoing reports to the court. And so you can nominate, and I always recommend you have at least one backup. And this person here, again, they'll work with an attorney in doing these things here, but they'll be the ones, if you need a appraisal, let's say, of real estate or something, they'd be the one to go out and secure the appraisal and give that paperwork back to the attorney. The attorney would then prepare the court paperwork for you to sign as the executor, and they would file it with the court and tell you what happens next. So, and as long as you know, love, and trust the executor and the alternate or two that you're appointing, that should work out just fine. Does anybody have any questions about last will and testament or anything we've kind of gone over so far?
So George, is it required by the state of Ohio to have an attorney when you pass to carry out the last will and testament, or can the executor appear in court and bypass the quote-unquote attorney's fees? If it's a simple last will and testament, can the executor go to court, present the last will and testament, ask the judge to do his thing, and eliminate that percentage that the attorney gets?
The attorney would need to be involved with anything to be filed with the court, because that's deemed to be the practice of law. Now, based on the size of the estate, there may be a more of a quick, time-shortened process for things to happen. For example, I think there's a dollar limit. I'll say that if it's super low, it's called a summary release from administration. If it's a little bit more than that, but not a ton, they call that a release from administration. And both of those are designed to basically, the attorney gives the judge some paperwork, and usually within a day or two, they will just sign off and say, we understand there's not a whole lot here. This is your distribution plan. We approve of it. You got 60 days to get this done, report back. And then they're called a commissioner, but they're doing the same function. They would go and do all that and report back. But you need an attorney for anything like that.
And does the executor have a standard rate governed by the state of Ohio of percentage of the estate that the executor can expect to receive? I know you can waive it if you want to, but is there a 2, 3, 4%?
Yeah, that's an excellent question. So there's a formula for both the attorney fee and also the executor fee. And I'm speaking from experience from Mercer County here, because I'm about 100% sure that all the county courts can, kind of set their own schedule, or fee schedule with all that. What was your exact question? I want to make sure I don't ramble too much.
Executors usually get 2-3%.
Yeah,
the attorney gets whatever percent.
For about the first $100,000, I believe the fee is roughly 4% of that. For the next 1 to, I think, 300,000, it might be 2 to 3, and then after that, I think it's about 1 to 2 in there. And that's a guideline only, because I will say that you could, like an attorney could certainly experience a windfall on the end of a very large estate, shall we say, and the court would probably look at that and say, well, that's, if they calculated out that it's $10,000 an hour the attorney earned, that they may not approve such a large fee. But for a smaller estate, it may require a lot of work that may exceed what the actual value is. In that case, the attorney could apply, or the executor also could apply for extraordinary fees, and that would be up to the court to ultimately make that determination.
Sometimes attorneys go by the hour instead of by the percentage of the estate, so I suppose that's negotiable between the executor and the attorney, I suppose, huh?
Yeah, and I think as long as the probate judge signs off on it, and I think that would be okay. And I think that's a great point to kind of also make with a lot of these decisions, whether there's a dispute or not, the probate judge will make the ultimate ruling in the case. If there's contested litigation, there's certainly appeals courts that could be looked to, but that's probably a different seminar, I guess.
Yeah.
This is just the basics here.
Yeah, that's good.
But yeah, any other questions about last will and testaments? See, you got your sheet there.
Yeah, I'm just gonna keep listening.
Okay.
Pop in.
Alrighty. So now I want to switch gears a little bit. We've talked about the last will and testament. And again, that's dealing with all your earthly stuff. And the other area of documents that people will often get done when they're calling an attorney's office deals with powers of attorney. They are separate from the last will and testament. Okay, a power of attorney is a document that somebody signs that gives another person authority to act on their behalf and in their best interests. To be as simply as possible, you know. And there's two types of powers of attorney. There's the medical, and then there's what I call the paperwork or everything else. Some will call that a durable power of attorney. The word durable, a legal term, it simply means that the document is intended to remain effective even if the maker suffers a mental incapacity and is no longer of sound mind. As long as that person is still alive, that power of attorney would be in effect. And this will often become an issue because you can get a power of attorney on a bank account. And let's say you have a sick relative or somebody that, you know, you're the agent on their account, and you're doing everything as you should, and that you're writing the checks for their monthly bills because that's how you've always done it, and they pass away, and the bank will then freeze that account based off the power of attorney authority has ceased upon death. Now, maybe this is a good time to segue into, you know, another part of the presentation here, but there's ways that you can make sure that those funds could still be accessed. And one of those is, I always recommend to call your financial institution to see what their internal forms are and what their regulations are. But usually, if you have somebody that you know, love, and trust, that phrase I keep using here, that you feel that, hey, when I die, my bank accounts, I don't believe that we need judicial oversight with these here, so I'm going to ask that they're paid on death, POD. That's the magic, or transfer on death, TOD. They're identical phrases, but it means that upon your death, as long as the recipient is alive and qualifies and accepts the funds, it should transfer in a very quick amount of time, perhaps within a few days, as opposed to going through probate. Even a quick order from the court is probably not quick enough to be paying the next monthly bills that are coming in. My accounts are personally set up this way here. I've got POD designations on them. If for some reason that person doesn't survive me, or they choose to not take the money, then if no alternate is listed, then it would simply just go through my estate. But my personal plan is to try to get things to move outside of the probate process. I don't want my wife to have to wait on money to free up to, you know, worry about paying the bills coming in. So yes, again, contact your, oh sure, down the hall and to the left. But make sure to contact your financial institution. Usually they'll just ask that you and the person or people that you're designating come in with your driver's licenses, I think, and to sign a document or two in the bank. So.
George, I got a question for you.
Yeah.
Ruthie and I have we have an estate, the Rumpel estate. And so we signed this probably 10, 12 years ago. And so one of the things that our estate services asks us to question, and this is a question for you, it says these POD or TOD designations. It says while they usually avoid probate, these types of accounts may be brought back into the estate by the judge. Also, POD and TOD accounts are ineffective when it relates to your incapacitation. So this, the reason I'm asking this question is, you said something about this durable power of attorney. So if I've got somebody designated as my health care power of attorney, but then a couple of doctors say, well, you can't handle your own affairs anymore for whatever reason. So at that point in time, my chosen person takes over. So that's for health issues and health decisions. But if it's got something to do with the bank, so is that still okay to have, in other words, health and what's the one for bank? Are they two separate things? Because this TOD, POD, is that separate from your designation, somebody helping you with the health care decisions?
It would be a separate designation. Right.
Separate designation.
Right.
So the attorney would have to create, like Ruthie and I, our paperwork, we've got State of Ohio Healthcare Power of Attorney. We also have a durable power of attorney.
Right, those are two separate documents that you have there, correct?
So the attorney then, say you're our attorney, you would create both of those sets of documents for us to sign.
Yes,
All right.
That's right.
And then the third one, then the living will declaration. So that's another document that we had to sign. It's from the state of Ohio.
Mm-hmm.
So that's the four that we're kind of interested in, and hopefully
Sure.
those are effective when it relates to a fellow's incapacitation.
So to answer your POA, POD account question about the judge like calling it back into court, like I can't say it's never happened. I have never experienced that. I've not heard of that. But that being said, I suppose if somebody wanted to challenge any of the standard challenges for when you have signed that payable on debt designation. So for example, that you weren't of sound mind, that you didn't understand the nature or extent of the document that you were signing or things like that, I suppose perhaps so.
Yeah, because this thing is warning us that if you have somebody on your account, your phrase is good. Trusting, you know them, you love them, and so forth.
Mm-hmm.
But theoretically, they could clean you out. If you were incapacitated, they could clean you out, and other people in your will wouldn't have anything to do about it.
I would agree that they could make transactions that would not be immediately discovered. However, there is a duty under the law which they have to act on your behalf and in your best interest unless you specifically grant that additional, I would say like stratospheric, extraordinary authority, which I have never had a client even ask for. Now that being said, if they do start writing checks to themselves or just cleaning out the accounts or whatever, we always tell people that do so at your own risk because you will likely face criminal and or severe to somebody, if you will.
So yeah, so if I died and somebody said, boy, Randy had $100,000, what happened to that? The other people is listed in my will. So at that point in time, somebody's got to explain, what happened.
Yeah. Yep. I would say the court would do their best to make sure that they're held accountable for, well, all their actions. I mean,
okay.
Yeah. Okay. Did you have any other?
No, that's
Okay.
good enough.
All right. Well, you had mentioned a living will. So we've got the durable power of attorney, which deals with paperwork, and then there's the medical power of attorney. The medical power of attorney is not the same thing as a living will. A living will says, in the event of end-of-life care decisions, and that is only with regards to those end-of-life care decisions. It's not these ongoing decisions, even if you're in a coma, if you will. So, but with regards to these end-of-life care decisions, which may be pulling the plug, it kind of says, in scenario A, do this. In scenario B, do this. And that's great. And often when you check into the hospital, they will ask, do you have a living will? And if you say no, they're very eager to see that you fill one out. And all that's okay. But we really don't do those for clients here because we recommend the medical power of attorney. And I believe that that would cover everything that you want in that living will and more. And here's why I say that. So in the medical power of attorney, first of all, it's effective only when you can't make decisions for yourself. So if you sign one here today and you go to the doctor and they say, well, here's what we want to do, your agent can't override that by any means. Another common question, if I personally sign a do not resuscitate order and then I go into a coma, can my agent override that? The answer is no, they cannot. Because your agent, again, it's similar to the financial duty, they have an obligation to act in your best interest. And they can't make any decisions impacting your imminent death, shall we say, unless they adhere to the medical standard. They have to have your doctor and then an independent doctor give you a medical examination and determine to the legal degree, to a reasonable degree of medical certainty, that basically whatever the life-sustaining treatment that they're providing for you, that if they pull it, whatever it is, that it's probably going to result in your death pretty quick. And there's also the general theory that if you're in a coma state at that point, that you perhaps don't feel pain. But they often will, I say, give you pain medication to help with the pain management if it's something along those lines. Morphine's a commonly known one that is used, and if that's something that's being used for pain management on your way out, if you will, your agent can't stop that because that would be cruel. I mean, again, at that point, the doctors have medically determined that you're probably not gonna come out of this if the machines are turned off. So you've designated a person and a backup or two in this medical POA. Now what? Now is the most important part, where you talk with your agents. Most will appoint a spouse and then maybe a child as an alternate, or two children as two alternates. And so these are, just an unpleasant moment, if you will, often at a family holiday gathering sometimes. It's like, oh, by the way, and don't just spring it on them, that I signed this. I would recommend talking to them beforehand to make sure that they're okay with, one, being given that power, if you will. Some don't believe that they would be able to handle that. And a lot of that may depend on the relationship between the people as well. That being said, I always say you don't necessarily need to appoint somebody that has medical knowledge. It would help, but as long as they are smart enough and are an advocate for your wishes to be carried out, that's the real key. I don't know hardly anything about medical knowledge here, but I know that I would be a very good advocate for whoever designated me. For example, I could say, well, they said if it's a ventilator issue, please keep them hooked up for a week. And I'd be willing to stand up to fight for that. Even if they say, well, the science says that after 3 days, I'd say, well, they said a week. Like, that's how, and I guess if there's an issue, then courts could get involved perhaps, at that point there. But I've sadly been around situations like that, and at some point, we just knew. You just knew when the right time was. you know.
I'm sorry.
Go ahead.
Just the question is, does it take a majority? So you say a spouse, that's cool.
No,
But you don't have a
it's
spouse.
in order of appointment.
Order of appointment, so
Yes.
you don't have to have a majority vote
You
to
do
keep
not.
the ventilator on. It's the person, single designation.
Yes, and I will say, in situations that I've been in, all the people listed on that form and others were, if not there physically, they were at least consulted on the phone and said, hey, this is kind of what they're saying here about all this. You know, and
The decision's still one person.
it is, I mean, there are legal avenues that can be filed, which have been filed, challenging such things. But I guess the key would be in avoiding such issues, and that's why I think it's important to talk with them all together. So there's not a question of, well, Dad said this to me, but well, he said this to me. Well, which is it? And what date was that? Well, I don't know. Did he text me? Did he email you? Like, what, you know, like that's not the time to be trying to figure out what Dad wanted. You know, so this came into play when COVID happened, where we had people calling asking, what do I need to do to make sure I can be hooked up to a ventilator? Because they'd never considered that before COVID happened. And all of a sudden they thought, well, I want at least a few days. And if that was something that's in the living will, you'd have to change that in that document. But with the medical POA, I said, you don't have to worry about getting germs coming in here. Remember that, right? So that was 5 years ago already. But I said, just call your people, you know, and just tell them, look, this is my wish right here. Make sure that they all know that you're calling all of them on this day here. And we would make a note in the file as well, in case anybody ever wants to call. We've got a time, date, stamp note in our file, you know. But yeah, there was no need to actually change the document. I always joke that I can't charge clients more money because they just did it all the first time.
Jason, do you have a question?
It was pretty much the same thing you were asking, because my mom has 3 of us, there's 3 children, and we kind of want to make all that decision together, keep the case up, but you have to have, like you're saying, one leader for all 3 of us, is basically what you're saying.
It makes the most sense to have a single appointed designee to me, but I think a lot of medical facilities like to make sure that all the necessary family are contacted, I guess, before they make or allow an irreversible decision to be made. That's, again, I don't have a whole lot of experience on that end there, but I don't have a lot of people that I'm thinking about it that call this office complaining, I was never given a chance to provide input for pulling the plug on insert relative here. So, yeah, but just, make sure, I guess, that your informal committee, if you will, like they're, in agreement with things. And at that point, you will have at least, if not your doctor, also that second independent doctor that has made that full examination that can say, here's what experience tells us with this.
George, in your seminar coming up, are you going to be speaking on the directive of guardianship by chance?
Guardianship, as far as if a court needs to make a determination for a disabled adult?
Well, yeah, so in other words, if like me, if I would start to show signs where I'm no longer able to make my own decisions for whatever reason, so these powers that you're talking about so far, is that part of or separate from a directive of guardianship where I choose somebody to be my guardian?
That is an excellent question. The Ohio legislature has put an optional provision in each of the 2 powers of attorney that we've discussed. The durable power of attorney for the paperwork and the medical power of attorney. And that section is the nomination of a guardian in each of those documents. Now, the way that the forms have been churned out by the legislature, when a client comes in and they're filling out both powers of attorney, I always go through it with them in the medical power of attorney for a couple reasons. Here's why. I think that if it ever comes to it, somebody would think that an attorney would spend more time talking with you about a guardianship when you're incapacitated in a document where you're talking about medical power of attorney that's only effective when you're incapacitated, versus when you're talking about going to the bank and going to, the credit union, or maybe going to the title agency. To me, I don't know that on the surface it would just seem that we may have had such an in-depth conversation. And I also like the form better. That's a secondary bonus, though, for the medical POA when it comes to this. And it's an option. It is not required to fill this out in there. But they've made it simple. They've said, if you want, and let me define what a guardianship is. If you think of a parent-child relationship, the child is a minor and the parent is the one who's able to legally act on their behalf and contractually bind them and things like that. And when you have a disabled adult, there is a legal proceeding. Somebody has to go file through the probate court. This is not a quick or cheap proceeding by any means, from what I understand. But there is, again, a lengthy, expensive process that somebody can file with the probate court that basically says, please designate a guardian for this disabled adult who is basically, we'll say, like a child, as a minor child in that respect. And so in the document, the medical POA, you can say, and here's what most people do. They initial the boxes that say, the same people that I've asked to be appointed for my agent here under this, if it ever comes down to it, and it shouldn't because of this document here, but if it ever comes down to it, you want those same people appointed in that same order by the judge to be your guardian. So it would, in effect, be the judge granting the same effect that you have granted in your medical power of attorney. You could list different people. There's nothing wrong with that, but I've never had a client want to list anybody different for that. And I always say, this is optional here, but you may as well also fill this part out. It's the only and best way that you can speak from beyond the coma about who you may want to be making those decisions, if the judge is going to have to appoint somebody as your guardian to do that.
So to summarize, you really don't feel, in your opinion, that those two need to be separate documents, that the medical healthcare power of attorney is sufficient for both tasks?
If the maker of that medical POA has appropriately filled out the form. And yeah, I would say so, because again, you can make designations in there asking that they pretty much have full ability to make any decisions with regards to your person or with regards to your property. And again, that would be only during the lifetime of the person, which that guardianship is established. But I don't think we would have to get there if the person had a valid medical power of attorney.
So that's where you step in and you guide that person along, and they fill out all the blanks and so forth, and so once you approve it, she's good to go.
Yep, and we make sure this is one that you have to make sure is properly notarized. Now here's an interesting tidbit. If you sign a medical POA and then you sign a living will, whatever is in that living will, if it's inconsistent with the medical POA, that's what they're supposed to follow. Because the general thought process is the document you sign last, that's probably what you mean. And that makes sense, perhaps. Maybe, again, maybe it's a case of mistake. Maybe you didn't know whatever the issue is that was in that document. Maybe you didn't understand the no ventilator, whatever it was, So I guess just be very aware of that. My general recommendation is that when somebody leaves here with a signed medical POA, we ask them to submit that to their primary care physician network. And usually that will populate to most of their medical charts. And if not, then we ask that you give a copy of that to those specialists who are outside of that same network there. And usually they'll just upload a copy into your file, give you your document back. And if they ask you in the future, would you like to sign a living will, we suggest to tell them, I already have a medical POA, you should have it on file. Could you please check to make sure that it is? Because the guess is that it's not on that little screen that they're reading to you at the time that you're checking in. It probably may be down somewhere further. So,
Good.
Any other questions on any of that? Okay. One question that we get asked a lot is when a loved one dies, who pays the bills? Nobody wants to pay any more than what they have to. And I will generally say that with very rare exception, unless you sign your name to be responsible for the debt of another, that cannot be enforced against you. Which is why when you co-sign for a car loan for a child or somebody that you love, you are on the hook for that, and they can enforce that against you. If you just went into the dealership and said, yeah, I'll back that loan up if they don't pay, that's not in writing. That's not going to be held enforceable. And so with one interesting exception that I've never encountered, which is where somebody's provided necessities for the deceased, so like food, clothing, or shelter, that they may be entitled to compensation for that. Again, I've never seen that. But generally, even if it's your spouse who has passed away, credit cards, this comes up a lot with credit cards. If the credit card was solely in your spouse's name, you've got a really good argument that that debt is only the debt of the estate of your spouse. Now, if there's more money than debt, that will be paid off. If there's more debt than funds, the court will order the order of priority that debts are paid and the amounts of those payments. And so without getting too detailed here, I will say that usually some of the highest priority of payments is executors and attorneys, because they want to make sure that people have some financial incentive to be working these cases through the court that need court orders. After that is when we get into governmental taxes and things like that. And then at the bottom of the list of priorities are those unsecured debts. So for example, your car loan's a secured debt because it's secured by the car. They'll repo the car if you don't pay. Well, your credit card, it's not tied to an asset, so it's an unsecured debt. And often those debts are, if there's nothing to pay, they usually get zeroed out. The creditors do have an opportunity to come and provide input into why that may cause them a hardship or are basically why it's unfair, and the judge, can take that into consideration as well. But I've seen where they've either given a proportional share to each. I've also seen where it was a fairly small estate, and the judge felt it was fairer for some more of the estate funds to go to the surviving spouse rather than Discover Card, which I thought was a great ruling because that was my client. But I'm sure Discover felt different. If somebody feels some moral obligation that they want to pay those debts of their deceased spouse, I would recommend that you maybe hold off on doing that at least until that estate is, at least till you talk to the estate attorney about that. Yes, sir.
I've heard this many, many times. Mom and dad give a kid $100,000 loan. Kid's got her 3/4 of the way paid off, and one or both parents die, and so they've got a $500,000 estate, and their will and testament says, 4 kids get her cut up, 4 ways. After all the bills are paid, assets go 4 ways. So here's the kid that still owes mom and dad, but he's going to get 1/4 of the cut of the estate. So is the judge solely responsible for interpreting the terms of the loan? Hopefully it's on paper and not just verbal. And his decision, this kid's got to pay that loan off before he can get any of the inheritance. So the kid has to go to the bank and get a loan from the bank in order to pay the estate, and then from the estate they pay back that money.
Assuming that the 4 kids are in dispute on the matter, I would certainly wait for a judicial order before doing anything on that. Now, what I would say is that there are steps that the parents could take in that scenario to address the issue. My first recommendation is in the loan documentation with the son there, perhaps they can address that in there, and also when they, or maybe they need to redo their will to address that issue. Because if you express that in a valid last will and testament, then at that point, I guess it kind of narrows the issues, maybe narrows the playing field a bit here. Now we're kind of dealing with, was the last will and testament, was it signed with a full understanding of what it was? Were they of sound mind when they signed it? Were they under any type of threat or duress or anything at the time that they signed it? Maybe the son puts something under their nose when they're having a moment where they're not in their right mind, and they just sign there, and so there's got to be 2 independent witnesses, and then maybe the other siblings question the will, and the judge asks these 2 witnesses to come in to provide testimony, and we go from there, I guess. So if there's no designation with that, if the parties could agree, then that's all the better. And that's a great point. Let me just make a little side point here. If there's no dispute with a potential issue, like if everybody works it out, that like sibling 1 gets the couch, sibling 2 gets the television, sibling 3 gets the refrigerator, and everybody's happy with that, and the will said equal shares, share and share alike, without giving you a laundry list of who gets what, if everybody's fine with it, then nobody's running to the judge complaining, right? So as long as, again, there's no issues filed, the court will just sign off on it then at that point. So the court is not looking to micromanage the estate. They're just trying to make sure that the decedent's wishes are carried out in accordance with Ohio law.
The best thing to do is have a piece of paper instead of a verbal agreement with the kid. Have a piece of paper regardless of the transaction between mom and dad and the kid. Always good to have it on paper, right?
I absolutely would. Even if it's, and depending on the size of the loan, it may be worth paying an attorney to draft a document. If it's a sizable amount of money, it and whatever that means to you. You know, it might be worth an attorney spending an hour drafting up something like that. But even if it's just handwritten out at the kitchen table that I agree that, you know, I'm being loaned X amount and I'll pay it back according to this schedule here. And however, if one dies during the repayment, this is the plan. If both parents die during the repayment, this is the plan. Like, that's better than nothing. I would try to, they used to call it the poor man's copyright, which is actually not like a legally valid thing for proving your copyright, where you would like make a recording and mail it to yourself and not open it, you know. But you can at least time, date stamp photographs of such a document, email them to yourself, so you've at least got something that says, I didn't just scratch this out the morning of court that I introduced it here, you know. We all sat around the table and we did this here. So, yeah. And the other area that we get asked a lot about is Medicaid recovery. If somebody receives any type of medical care in a nursing home that the federal government has paid basically anything for, they are entitled to be reimbursed. And we always get asked, how do I avoid Medicaid recovery? And the answer is there's no magic wand. There's no like secret door that I can show you. Just walk through here, because if I always half joke, the IRS together spells theirs. And that's how the federal government collects what they deem to be theirs. And they deem that this is theirs. Now, there is a system in place for how this all works. And I will say that generally they will not enforce this lien here on the home if there's a surviving spouse. From the way I understand that this is both written and enforced. Because they're not looking to put out the surviving spouse as a homeless street person. But at some point, when that surviving spouse does pass away, even if they themselves didn't receive that care that the feds are entitled to recovery for, that house is subject to recovery. If there's a transfer within the preceding 5 years, that is subject to basically being undone and reclaimed as part of the recoverable estate. So the only real way, from a legal perspective, to get around the Medicaid recovery would be if you transfer property and then live more than 5 years. Because as it's written right now, they can't go back and reclaim that. I've often wondered, what if they extend that period out at some point, make it 6 or 7 years or something? And the answer is, I don't know. The U.S. Supreme Court would probably be the one to interpret that. I mean, there may be a constitutional taking issue under the takings clause. I'm just thinking of it here in passing. But like I say, they do take a look at the cases that cross their desk. I did have a case where the deceased had, I believe it was a vehicle valued at about $1,500, and her medical care was north of $400,000. And the attorney reached out and said, is this the only asset this person had? I said, yes. And he said, does she have any next of kin? I said, she has a daughter. Does she want the car? Yes, she does. He said, well, she can have it. I'll send you a letter that says she can have it, because it, probably wasn't worth his time or effort on, a drop in the ocean on that. So, it's a regional attorney. I believe he's out of Sydney that handles for our area here. So they do try to look at situations as well. But I would also talk to a tax preparer, somebody that knows the IRS rules and regulations, before you just start transferring property. I'm not a tax attorney, but I've always heard it said that it's a better tax consequence for you to have your property be inherited after you die versus to transfer it during your life. And I think that has to do with capital gains that you would have to pay based on that transfer. But the tax code changes, and again, my disclaimer, I'm not a tax attorney, but there's certain tax rules, etc., also associated with gifting. So you have to be aware of that. Any questions?
Real quick one for your edification. So the guy's in nursing homes on Medicaid. Before he died, he inherited from an uncle $500,000. But he was in the nursing home for 8 years, and so you can imagine what his bill was. So that inheritance versus he was on Medicaid for that time, his inheritance went right through him back into the federal government. And they got most of that, if not all of that inheritance, to satisfy the Medicaid that they had already paid for his nursing home care.
I believe it. The IRS stills theirs, as I like to say.
Yep, so nothing you can do about that.
You are generally correct. I wish there was a magic way to make it happen, but not to my knowledge. So, well, again, thank you for coming in. If there's no other questions, you're free to go, if you will. So, thanks again for coming.
Thank you.
Thank you.
So if